Good morning and welcome to our March, actually, I guess we've spilled into March now, March edition of our monthly webinar series, trying to bring you relevant topics of interest to the small and medium and large business community here. I'm Steve Rosansky, President and CEO of the Newport Beach Chamber of Commerce, and we're happy to have with us this morning Todd Wulffson. Todd's an attorney, and I'll go over his bio in just a minute. But I did want to just bring you up to speed on exactly what we're going to be doing this morning. So we're going to hear Todd's presentation, and Todd's going to answer any questions that you have towards the end of the presentation. If you would be so kind as to put the questions in the Q&A box, not in the chat box. So we'll be monitoring the Q&A box for questions, and we'll hope to get to most, if not all of them, at the end. This is a topic that I think is very relevant to any business, whether you're an employee or a business owner. What your rights are with regard to coronavirus and your workplace. There's been a lot of new legislation and regulations that I'm sure Todd's going to make us aware of, and we're going to find out the best way to treat your employees as the law requires, and give them the respect that they deserve under the circumstances. Todd does have a PowerPoint presentation today. I put the link in the chat box, so if you want to download his slides afterwards, so you don't have to take a bunch of notes during the presentation, feel free to use the link, and you can download the whole presentation. Why don't we just jump into it here? I'm going to read Todd's short bio here, and then we'll turn it over to him. So Todd Wulffson is Orange County Office Managing Partner of CDF Labor Law LLP, a California-based labor and employment and immigration law firm with offices throughout the state. His focus is practiced on counseling and defending businesses in labor and employment matters for over 30 years. In addition to private practice, from 2006 to 2010, he served as General Counsel and Senior Vice President of Human Resources to Palace Entertainment. Todd is also a frequent speaker, author, and resource to employers with workforces in California on employment-related matters ranging from terminations, sexual harassment, pay practices, and classification of employees. So with that introduction, tell me a little bit about Palace Entertainment, though. That kind of intrigued me. Is that the place where you go outside and you play like miniature golf and all those?
Yeah, at the time they owned Boomers, Raging Waters,
Boomers,
Free, Speed Zone, small amusement parks all cobbled together, 11 states, 30 parks, and about 12,000 employees.
Yeah, I think we have one right off the freeway.
Yeah, it's Michelson and over Michelson and Harvard.
Yeah. Okay, great. Well, I'm going to shut my video off here and turn the presentation over to you, Todd.
Thanks, Steve. Yes, as Steve mentioned, not only am I a lawyer, but now, given COVID, I play one on TV. So let me share my screen here. And start the slides. All right. So yes, this is my high school prom picture. And I actually put my high school graduation on there to show you all that I'm born and raised in Newport Beach, not just someone brought in from outside. We've already done the commercial for the firm. For purposes of today, kind of as an overview, if anything I say generates a question, as Steve mentioned, put it in the Q&A box for the end. If you think of a question afterwards, or you have a question that you really don't want 70 or so witnesses to, feel free to shoot me an email afterwards. My email is at the beginning and the end of the slide presentation. I don't bill for emails and phone calls anyway, so shoot me an email and we can discuss whatever specific issue you have. And also, I'm going to be mentioning throughout lots of different kinds of templates, of exemplars, if you will, of things that you probably should have done already with your employees. Any one of those, I have those templates. So just shoot me an email afterwards and say, hey, Todd, please send me the COVID response plan you talked about, and I'll send you a template. The only caveat being is obviously I'm not necessarily your lawyer, so I would recommend that you have that customized and go over it with your counsel. If you don't have counsel, I'm happy to discuss it with you, but these are generic templates, but they will get you 90% of the way there to resolve some of the issues we're going to talk about. We're going to be going over the litigation trends, and the real focus here is I try to be as pragmatic as possible. So we're going to be talking about what you should be doing to avoid being sued. or having ongoing liability concerns about what is an ever-changing and evolving landscape that is COVID. Started March of last year, and we've probably had 50 different iterations of the various regulations. We'll be talking about testing and vaccinations, what you should be focused on, and then of course, how to roll this out to your employees and really your management, because they're the most important. If your managers are not on board with this, if they say the wrong thing, do the wrong thing, react the wrong way to an employee, that's where your liability is going to go. So let's talk about the fact that California, but for the weather, no one would choose to have a business here. We do have good weather, but it's a horrible environment. We've got federal law, we've got OSHA, we've got CDC, the Centers for Disease Control guidance. We've got Cal OSHA, who sometimes takes a different view than Fed OSHA, and we've also got the Governor Newsom's executive orders that roll out every few weeks with new recommendations, ranging from recommendations to laws. I'm going to say this in as non-political a way as I can. There really is no legislative authority for much of what has been done with respect to COVID. There's no legislative authority, for example, to shut down businesses, to shut down schools. The legislature in the state has to do that. Obviously, it's been a political issue, and it's been rapidly evolving. So governors in many states, including our own, have jumped in. But when you're dealing with all those different laws, the best thing to do is try to comply with federal law and comply with the executive orders. But keep in mind, Orange County has regulations. A lot of cities have regulation. Newport Beach is very employer friendly. So I like the fact that Newport Beach doesn't have anything to hassle with any of the businesses, but Los Angeles, San Diego, San Jose, Santa Cruz, Oakland, Alameda, all of those cities have passed ordinances that are on top of the federal law and the state law. So if any of you have operations there, if you have employees working there, and we'll talk about this later, but if you have employees working from home there, you need to comply with the law where your employees are actually performing their services. And I know the tagline for this was, did you know that the California is the COVID capital of the United States? Well, it shouldn't surprise anybody, but here's exactly how much of a capital it is. Out of the 1,800 or so lawsuits that have been filed in the United States based on COVID-related employment litigation, 426 as of last week were filed in California. The second state is New Jersey, which is 213. So it's exactly half. And then, most of the states are in the double or even single digits. So California is the hotbed of litigation for purposes of COVID. And the goal today is to give you all the information you need to avoid being the victim of one of these lawsuits. All right, so we have California has its unique tiered system. As we all know, we're currently in the purple tier, but we're going to red, and then it goes to orange, and then it goes to yellow. All of those are bad colors. They're all colors of danger or warning. There is no green tier. If the tiers disappear, I guess then we'll be green. But I've listed here all of the links that you can look at. These are the best links for an employer to go to see what the rules are at the current time for purposes of what you can and can't do. So for example, if you go to the covid19.ca.gov and you put in Orange County, it'll tell you based on your industry what tier you're in and what you should be doing currently. So for example, your restaurant, right now outdoor dining is allowed, but I know a lot of restaurants are doing indoor dining and they're looking at the next tier so they can comply with that in advance. The best overall site for California is the California Department of Public Health. It's a kind of a combination of the recommended guidance from the CDC, from OSHA, and what California has done is an overlay. So if you're looking to look at a website to say what kind of PPE, personal protective equipment I should have, what kind of, what in an office environment, if we're open, what should we be doing in terms of sanitizers or hand washing or social distancing. It's all on the California Department of Public Health website. And then there is a very good site that Orange County has put together for businesses. It's on here too, OC COVID-19 at oc.ochealthinfo.com. And then of course, the CDC guidance. The CDC changes quite a bit, as you'll all remember when this thing first started. Masks were not recommended. As a matter of fact, the Surgeon General got on TV and told people not to buy masks. We learned later that was because there weren't enough masks to go around. Then masks rolled out, but masks changed. What kind of masks needed to be done? Some masks were banned, some masks are allowed. And now the current recommendation from the CDC is to have 2 masks. And I can tell you right now that the CDC is in the process of updating its site right now, because when they put a 2-mask recommendation out there, people were taking N95 masks and doubling them up. And for those of you that have worn an N95 mask, which literally means 95% of all particles are kept out, if you have 2 of those on there, you can't breathe. And people were literally passing out at work because they were wearing 2 double N95 masks. The recommendation right now is that you wear a surgical mask or a disposable mask and then a cloth mask on top of it. The cloth mask is there to hold the disposable mask more in place. There is not a recommendation, like I said, the CDC is now updating its website to say, do not wear 2 disposable masks, do not wear 2 surgical masks, do not wear 2 N95 masks, and don't wear 2 cloth masks either, because it just means that one of them is going to fit in an inferior way. So you as an employer should be reviewing these. Have your designated COVID person, and we'll talk about who that is, but have someone whose job it is basically to go on and make sure that you're in compliance and you're reviewing all these things. And tell your employees, just say, look, we are monitoring the OSHA websites, we're monitoring the CDC websites, we're monitoring the Orange County websites, we're monitoring everything we need to do to keep you safe. It reduces anxiety among the employees, and will also ultimately reduce your liability, because if there is a problem and OSHA comes knocking on your door, and they're going to talk to your employees, you want them to say, oh yeah, my employer's been talking about monitoring the websites, and we have this COVID plan, and we've got training, with all these things we've done to avoid liability. It'll give the investigator a heightened sense of confidence, and it will hopefully help you avoid liability because you're doing all the right things. All right, let's talk about the types of lawsuits that are being brought and kind of a pragmatic approach on how to avoid them. Since COVID hit, it's been a hodgepodge of opinions on what should or could happen. There's a lot of lawsuits right now being brought over the fact that you didn't provide a safe environment, either for employees or for customers. Now, for employees, one of the things that the governor did that has some good points is, in California, it's been mandated that if you have been in the workplace for more than 14 days and you acquire COVID, it's deemed to be a workers' comp related event. Now, the good news is it keeps your employees from suing you for things like negligence or gross negligence or willful misconduct, things like that. The bad news is, as we know, most employees are not getting COVID at work, and it's going to mess with your experience modification rating with your workers' comp carrier. As you all know, your workers' comp insurance is based on the amount of money paid out the prior year. So if in fact you have a whole bunch of employees that get COVID and it's a workers' comp claim, that could dramatically increase your rates. But the current trend right now in California is most claims are not being found to be work related, but since it's a workers' comp related event, it avoids them from negligence claims. However, any invitee to your premises, so the FedEx delivery person, your customers, vendors, anybody that comes on site, they're not covered by workers' comp. So if you don't have an appropriate COVID response policy in place, they can sue for negligence. And the new big lawsuit that I'm sure you've probably seen on the news is people are suing, claiming that you gave me COVID and I took it home and gave it to my grandmother, my mother, my uncle, whatever the issue is. I went to a family gathering and infected my entire family, and it's your fault because you forced me to come into your facility and I wasn't wearing proper PPE, and that's the theory of the lawsuit. And by the way, on the PPE thing, it's kind of universally known that the reason you wear a mask is to prevent other people from being infected by you. The mask does not protect you from being infected by other people. The N95 mask is a lot better than having no protection at all, but a cloth mask is designed to catch your droplets to keep you from infecting other people. And a lot of people don't understand that, so they wear a cloth mask around, they get COVID, and now they're bringing lawsuits claiming that, you know, the business didn't provide enough protection against them. The typical allegations that come from employees, that the personal protective equipment was not provided by the employer. In California, we got Labor Code Section 2802 that says if there's anything that's required to do the job, the employer has to provide it. So you should have disposable masks available for employees. If they don't bring their own, if they want to buy their own, you should reimburse them for it. If you want to avoid having them go buy one of the real fancy rhinestone ones or whatever, then you can tell them, look, we're providing disposable masks, or we'll reimburse you for the standard cost of a cloth mask, but we're not going to reimburse you for one that's been autographed by Madonna or something. The current OSHA recommendation is that gaiters, you pull up around your neck, vented masks and bandanas are not approved PPE. So if you see employees wearing those, you have an obligation to tell them that's not an allowed PPE, and you need to provide them with a surgical mask or something else, a disposable mask of some kind. Disposable masks need to be changed out every day or more often. If they get wet, they need to be changed immediately. And you should have a ready supply available, because that's a pretty easy lawsuit to bring for an employee on behalf of all the other employees to say, oh, there wasn't enough PPE, that's why we all got sick. Failure to implement testing policies, we're going to talk a little bit more about that later, but not having any kind of a screening or a testing policy or procedure, that's getting employers sued. So you want to make sure that you have that, and we'll talk about that actually in the next slide. And let's talk kind of quickly about the types of lawsuits that can be brought. In California, California's been functionally bankrupt for a very long time, and about 12 years ago, they came up with this great theory of, since California doesn't have the resources to sue employers for all the potential violations that might occur, either wage and hour, labor code, whatever, California's unique in this regard, passed what's been known as the Private Attorneys General Act. It allows any individual that's an employee or a lawyer for the employer to bring an action on behalf of all of the aggrieved people who have suffered the same harm. So it could be an overtime claim, it could be missed meal period claim, and in the age of COVID, it's failure to provide safe equipment, failure to provide the proper equipment, failure to reimburse, and failure to have an injury and illness prevention program that has a COVID-19 response plan in it. All of those things are now being brought. So you want to make sure that you have a plan. Let's switch over to this one. One of the most important things to do, if you haven't done so already, is all of you should have an injury and illness prevention program. If you're a California employer, you should have had it for at least the last 15 years. If you don't have one of those, there's lots of consultants that can do it. I can provide you a template, but it really is going to be specific to your workplace. What I can provide you, if you don't have it, is the COVID-19 response plan that's the addendum to your injury and illness prevention program. It is the first thing that the County of Orange, the Health Department, or OSHA is going to ask you for if there's any kind of an outbreak or any kind of a problem in your facility. You need to have a COVID-19 response plan, and it says in there, it's fairly lengthy actually, and again, I got a template, but you have to designate someone as the COVID-19 response person, so all employees can go to him or her and raise whatever issues you have. It lays out how you're going to inspect the facility. It lays out how you're going to do the cleaning, how you're going to do hand washing, sanitizing, social distancing. In our law firm here, for example, a lot of the folks have private offices, and as long as you're in your private office with the door closed, you don't need to wear a mask. But if you're in an office environment, otherwise, if you're going to the bathroom or walking downstairs to the lobby, you need to have a mask on. Your COVID-19 response plan needs to lay all that out. It needs to also list all the hazards for each of your facilities. And again, if there is a reportable event, first thing they're going to ask for is your COVID-19 response plan, and your managers need to know and be trained to it, so that when OSHA asks them, hey, tell me about your COVID-19 response plan, the worst thing that can happen is your manager can say, well, what are you talking about? I have no idea. If that happens, you've got the risk of actually being shut down. But if your manager says, oh yeah, we got a COVID-19 response plan, our COVID, our coordinator is our HR director, you're fine. But you need to have that. Part of the plan also is going to tell employees, look, if you feel sick, stay home. It's going to talk about how you're doing screening. I don't recommend temperature checks. Temperature checks are problematic for a number of reasons. First of all, while people are waiting in line to get their temperature checked, you got to pay them for that. If they get to the front of the line and they have a temperature that's more than 100.4, you got to send them home. And guess what? You have to pay them for showing up to work, even though they showed up to work sick. And you got to pay them at least 2 hours, maximum 4 hours, or otherwise half of what their regular shift is if they came to work sick. Employees figure that out pretty quickly, not to be overly cynical, but that's kind of my job. And employees will realize that if they go to work with a fever, they're going to get 2 hours of free money just for showing up. So a better situation is to have in your COVID response plan that people will check their temperature at home as part of their regular morning routine. And when they get to work, you should ask them the standard questions of, has anybody in your household been infected? Anybody in your household have these following symptoms? Have you had all these symptoms? And I have the standard questions. So shoot me an email if you don't have those questions. They should be asked of anyone that enters your facility every day and then every week. But basically, it's, are you experiencing symptoms? Anyone in your household experiencing symptoms? Has anyone been diagnosed or treated for COVID symptoms in the last 14 days? Those types of things. And again, I have that template. And the other thing with temperature screening is all you got to do is chew a couple Tylenol, and your temperature goes down. So it's not terribly effective to block people from coming in, but you need to have some kind of a screening process as part of your COVID-19 response plan, or you do not have a safe and healthful workplace under California law and are subject to an individual or class action lawsuit. Let's talk about working from home. The recommendation for purple tier is that everyone who can work from home should work from home. And that's great until you talk about the logistical issues of, well, what does that mean? Who has to work from home? And we have to have at least a skeletal crew working at the facility. What happens with those people? That's also all dealt with in your COVID-19 response plan. And for anyone that works from home, I know I'm skipping ahead to the end of the slide here, but make sure you have a work from home policy that is given to the employees that says specifically, what's expected of them, what they should be doing with their home workplace, what's reimbursed, all of those issues. I have a generic template on that for exempt employees, and I have one for non-exempt employees, because obviously it's different, because non-exempt employees, you need to remind them, even though they're at home, hey, take a break, walk into the kitchen for at least 10 minutes and have a snack, and make sure you take at least a half hour off for lunch, and document all of those things. That's all in the work from home policy you should have. Some of the things that are getting employers sued with working from home, and this one is one of the non-intuitive ones. Probably the number one lawsuit that's happening right now with working from home is liability relating to data breach. So you've got employees working from home that have never worked from home before. They now all of a sudden have access to your server, which in the workplace, you've got the encryption on the desktops or the laptops in the workplace. You've got access to your server restricted, but you have to open that all up because people are now working from home. So people from home have their laptop and they go to Starbucks because there's free Wi-Fi, and they leave their laptop there, and the laptop is left on. And now whoever picks up that laptop has access to everything on your confidential server. And if I had a client, for example, in the mortgage business, and this exactly is what happened to them. The laptop was left at Starbucks. They had to pay for LifeLock for all of their employees because the laptop had access to confidential employee files. So 1,800 employees got 1 year of free LifeLock as the settlement for the data breach. If you have consumer information on there, the potential damages are exponential. You have to have some kind of actionable security. So if, for example, if you sandbox the programs so that employees can only access the program with their device in a certain way. Maybe you have a Citrix server where they have to log in, but the cell phones that access your server have to be security protected. The laptops have to be security protected. You have to have taken appropriate steps, because that is not a workers' comp issue. That is a negligence issue. And if you fail to comply with a reasonable standard in your industry for purposes of consumer security or employee data security, you're exposing yourself to a lawsuit, which can, on the margin, be a violation for every single person who has their information lost. And it's not really good for your PR either. for you to be in a like financial services position and have people find out that you were found liable for a data breach. People are going to move on to another company that doesn't have data breach problems. When employees are working from home, you have to reimburse them for everything needed to do their job. Now, you don't need to buy them a chair and a desk because people have a chair and a desk, at home, or I don't care, they use a dining room table. But if someone needs a specific chair, like an ergonomic chair, because their medical condition or their disability, or they have a bad back, you have to provide that chair, and you want to be involved in providing that chair, because if you just say to the employee, "Hey, go ahead and buy yourself an appropriate chair," I mean, an ergonomic chair at Office Depot can cost you $200. You could buy chair I'm sitting in right now, an X chair. I mean, it's like $1,200. The last thing you want is your employees to run off and buy the most expensive chair out there. So you want to have parameters for them if in fact they need it. And you want to tell them, and the work from home policy I have says, make sure you let us know what you need, and we'll either provide it for you or authorize reimbursement. When you have employees that are required to work from home, you're going to have a lot more items that are going to be necessary to buy for them. So whatever they need, a desk blotter, desk equipment, a light, or like I said, an ergonomic chair. If you're requiring them to work from home, you have to provide all that stuff. If the employees have the option to work from home, there's a lot less scrutiny with respect to what you need to provide, because after all, they're choosing to do it. You still need to provide, a laptop. You may have to provide a printer. You may have to provide a scanner, those types of things. But as we're moving into more of a hybrid model, the hybrid model is that people are working part-time at home, part-time in the workplace. That's actually a good way of doing it, because you can incorporate that in your work from home policy and tell people things like, for example, since the expectation is that you're going to be working from home part of the time, when you come to the office, that's not compensable time. Because if you tell people your workplace is your home, your job assignment is to work from home, and then you say, hey, we're having a team meeting next week, and they come to the office, for a non-exempt employee, an hourly employee, that's compensable time. You got to pay them not only for the mileage to drive to the office, but for the time spent driving to the office, because you've now mandated travel during the workday under California law, actually under federal law too. So having a work from home policy that says, your time spent commuting into the office is not going to be compensable because you're working a hybrid model, or you've chosen to work from home, therefore we're not going to pay you for the travel time to come to the office, will avoid a lot of issues where, in a class action context in California, is whenever you have commonality of claims among the employees. So if they all have the same issue, none of them are getting a break, none of them are getting a lunch, none of them are getting paid for their time driving from home to work. Those are easy class action claims, and all you need is one employee. You could have 500 employees, and 499 can swear in a Bible they don't want this lawsuit brought on their behalf. But that one employee that doesn't can bring an action on behalf of all 499 other employees, whether they want it or not, as a class action, if there is some kind of systemic type problem. So you really want to avoid having broad-based potential violations. A couple other things to remind folks with working from home. If they're working from home, I mentioned before, you got to tell them what their breaks are, what their meal period are. It's the same as if they were at work, and they need to document them either on their timesheet, or if you've got a POS system for them to log in and log out, they need to document the fact they're getting at least 30 minutes relieved of all duties while working from home. Exempt employees, don't worry about that. You can work exempt employees 24/7. And all you have really is, it's not a legal issue. It's just kind of, at some point, they're just going to go crazy and leave you. I know a lot of employers have decided that they're going to make everyone exempt because they're salespeople, and outside salespersons are exempt under federal and California law. Unfortunately, if someone's working from home, they're not an outside salesperson. Outside salesperson does not mean they're outside of your business. It means they're outside of any office. So think, door-to-door salesman. A door-to-door salesperson is someone who's out selling. In the mortgage industry, a lot of real estate folks are spending all their time going from referral source to referral source. They're out traveling. They're not at any one particular place. But unless you're spending, about 80% of your time out of any office environment, including a home environment, the person's not an outside salesperson. And that, again, is also something that's a really easy class action issue, and will get a plaintiffs' employment lawyers slobbering if they find out that you've got several hundred employees who have been misclassified as outside salespeople. For people working from home, their home is their work environment. So if they're a hoarder and they have piles of stuff all around and wires everywhere and all that, and they trip and fall, it's a workers' comp event. So you want to have as part of your work from home policy something in there letting the employee know it's their responsibility to make sure it's safe, and letting them know also that you have the ability to come and take a look at their office environment at home to make sure that it's safe. I'm not recommending that you just show up unannounced at your employee's threshold, but let them know that we're going to take reasonable steps if we, for example, on a Zoom meeting, see that all around you is piles of old telephone books. I don't know why anybody keeps telephone books anymore. That you're on notice that it's an unsafe environment. So make sure that you at least have the ability to inspect and put the onus on the employee to have the workplace safe. All right. Discrimination claims. Discrimination claims can come because the person was laid off or furloughed. The discrimination claim can also come, and the most common now is as people are returning to work. You didn't return me to work first, or you didn't return me to work at all. I had a client call me up a couple months ago, and they say, "Well, yeah, Todd, we got this demand letter, and we brought everyone back from work. Well, everyone except for the people over 65, because Governor Newsom said if they're over 65, you need to protect them." Well, that's not exactly what Governor Newsom said. He said that people over 65, need to have, they're especially vulnerable and they need extra protection. Extra protection does not mean they don't get to come to work. You don't want to be and can't really be under the law overly paternalistic. When you bring people back, it's no different than kind of a hiring situation or a layoff situation. You want to go through, the population of your employees as a whole, and the subset of employees that you're returning to work or you're giving some kind of net benefit of the employment, and take a look, on the age, race, gender, all the protected characteristics. Is the group of people that we're selecting, about what you would expect based on our overall population. So if you've got 100 employees and you're bringing 20 back to work, if those 20 employees are all male, you got a problem. If they're all white, you got a problem. If they're all 30, you got a problem. So you want to make sure that you're screening the groups of folks so that everyone's treated kind of consistently in a way that doesn't look like there's some kind of a disparate impact in a particular group. Now, disabilities is the more difficult one, because California recognizes actual disabilities, which means you've got some kind of a physical or mental limitation that prevents you from doing an essential function of the job, but you have to take a look at whether or not there's a reasonable accommodation. So is this a substantial impairment on a major life activity that can be accommodated, or is it a substantial impairment that can't be accommodated? All of that requires what's called an interactive process, which means you're having emails, phone calls with all your employees to find out who actually has a limitation, who does not. By the way, trying to avoid talking to your employees over text. Texts aren't backed up on your server. There's no documentation for it. And texts are really easy to modify. I see them all the time in depositions I'm doing with plaintiffs. People have a text message that no one's ever seen before because they literally created that text message. So try to keep all your communications through official channels that you control on the email system that goes through your server. Letters that can be sent as an email attachment. I think we mail letters anymore, but and if you have a phone call, make sure you follow up the phone call with an email or some kind of documentation. But employees are going to claim when they're returning to work, I can't come back to work because I have a cough and I feel like I'm still potentially subject to COVID. That needs to be explored. You look for a medical certification to see if in fact they're ill. The big one now is particularly as vaccinations are starting to roll out, people are still refusing to come to work because they're scared they're going to get COVID. They've been watching way too much TV, and they're concerned that they can't walk outside of their home. And I'm not making light of that. There's a significant increase in various phobias, including agoraphobia, fear of going outside, fear of being around people. And if your employee legitimately has a fear of going outside until the world's been vaccinated, that may actually be a disability under California law. It needs to be accommodated. The accommodation may be, all right, well, then you can stay home on an unpaid leave. You're not going to lose your job, But for the time being, we're going to have someone else cover your responsibilities until you're able to come back. And make sure that that person can't work from home, because obviously the best accommodation for someone, particularly in the purple tier where we are now, is if they can work from home, they should work from home. But if someone says, look, I'm sorry, I can't do it. I can't bring myself to come to work until, there's herd immunity, you're going to need to accommodate those folks. Another very large claim that's been getting a lot of press recently is there's been a lot of discrimination, real and perceived, against the Asian community, either because the perception that the disease started in China, and I think everyone kind of agrees that it did, but why you then enforce that on a third generation Chinese American who has never been to China, I don't understand. But there is a good backlash right now that's getting a lot of media attention that can result in liability. So if your managers hear people in the break room talking about, the Wuhan flu or something like that, they need to know that there's no difference between that and walking in the break room and having some guy do a wolf whistle at a female employee or comment on how hot her legs look. I mean, it's the same type of liability. It's just as inappropriate and needs to be handled the same way. So make sure your managers understand that you're not going to tolerate, and you have a zero tolerance for any kind of discrimination. And the discrimination is not just against Asian Americans. The discrimination also is against people that have had COVID. I have probably a dozen lawsuits right now that are related to the fact that people were treated differently after they got COVID. Either they weren't brought back because the perception was that they could infect people, or the company was trying to be paternalistic and protective of them and said, well, we didn't want to bring you back really yet because we figured you'd be weak and not able to do your job. The most people that get COVID are asymptomatic. I got it in January of last year. I had a fever for 2 days. It went away and had no other symptoms. My wife was completely asymptomatic, and we're not exactly young. So it really ranges. So you shouldn't assume that anyone can't do the job or is going to react differently because they've had COVID. They should be treated the same way as everyone else, with no difference, because the result is they can have a discrimination claim or retaliation claim against your business. All right, whistleblower claims. This has also been a very big jump, probably tenfold related to COVID, as what you would expect in a normal year. The issue here really is people are complaining about something in the workplace. They say, I don't want to come to work because I don't think the workplace is safe. I don't think that there's enough PPE. I don't think that there's enough social distancing. They send that email to HR and they're not brought back from being laid off. They're disciplined at work. You realize you brought people back too early and you send them back home, or you terminate their employment. The argument can be, you terminated me because I raised an issue relating to something illegal in the workplace. Labor Code 1102.5 basically says if an employee is told to do something illegal, or if they're asked to do something they perceive as illegal, they can bring a lawsuit for retaliation. They don't need a lawyer. They can go directly to the Labor Commissioner's office. If they have a lawyer and they win, they get automatic attorney's fees. But the Labor Commissioner will bring those claims on their own. I think the California Labor Commissioner's office said that I think it's eightfold increase in whistleblower claims from 2019 to 2020, and almost all of them are related to COVID. So any complaint you have from any employee relating to something that sounds like it's a COVID concern needs to be investigated. Run it by counsel. Run it by, if you got HR on site. Make sure someone that is trained to deal with it investigates it and resolves it as best you can. And it's best to have the same person or the same committee resolving all these things. One of the reasons you want to have a COVID response coordinator, or whether it's in-house counsel, outside counsel, or your HR director, the same person should be reviewing all the various issues and coming up with the same potential resolution, because you want to be consistent. You don't want to have your COVID response in Newport Beach be different than your COVID response in Riverside. You don't have to be different, in California than it is in Nevada. You want to make sure that your response to COVID, the virus doesn't know what state it's in, so you should be responding the same way throughout, so you don't get the argument that you're treating people negatively or better. And for example, if the issue is Newport Beach versus Riverside. You don't have the argument that you're treating people better in Newport Beach because the people in Newport Beach, on average, tend to be whiter than the people in Riverside. I've seen that quite a bit when you've got companies with varying demographics in different areas. So make sure you're doing it consistently. And as a final thing, OSHA, you can also go directly to OSHA and complain that I don't think the workplace is safe or helpful. OSHA will do an investigation. They're doing them all by Zoom right now. If they actually show up at your facility, you're in big trouble because there's only a few people that are doing investigations on site for OSHA, and they think you have a super big problem if they're actually showing up. But they'll call you and they'll send you a letter and they'll ask you for a bunch of documents and they'll tie up a whole lot of your time because some employee complained that the workplace isn't safe. Best way to avoid some of the whistleblower claims, monitor all of the various guidances out there. And like I mentioned before, tell the employees that you're doing it. Send emails out saying, hey, just want y'all to know that I'm sure you've seen in the news that the CDC is now recommending double masking. We have masks available, but the CDC is not recommending using 2 disposable masks. It's not recommending 2 N95 masks. What it's recommending is a cloth mask over a disposable mask. And as you all know, we'll reimburse you for the cost of a cloth mask, and we provide the disposable mask here. Make sure you have all of your policies, your COVID response plan, for example, updated. So as situation changes, when the CDC recommends double masking, put it in your policy. Let people know that it's current. Let an OSHA investigator know that it's current. Make sure you have a really clear communication structure for, and make it welcoming to employees. Look, if you have any concern at all, this is a crazy time. No request is going to be seen as is too little or too ridiculous. Bring it to us and we'll resolve it. Because like I said, some of the claims that sound a little ridiculous, like during Thanksgiving, a lot of lawsuits were brought because people said, oh, I got sick at your facility, I got sick at your business, and I gave COVID to everyone in my family. It's your fault. There's no way you can prove that you got COVID at one particular business. But if your business gets written up in the paper or online for having a COVID outbreak, you're going to get lawsuits because people that have visited your facility are going to say, aha, I've now got someone who has been found to have been violating the rules. You're now a target. And make sure you've got a COVID-19 response person and all of your managers trained to treat everything as they would a harassment or discrimination claim. Have all your managers trained to say, the 3 simple things of when an employee complains to them. Thank you for bringing it to my attention. I had no idea that this was an issue or concern of yours. I'm going to make sure this gets resolved by HR, our general counsel, our COVID response person as soon as possible. Your manager should not be resolving it on his or her own. They should be turning it over to the appropriate person, just like they would with a harassment or discrimination claim. And I mentioned before, make sure you document everything you're doing. Email is good, but make sure the right person is documenting consistently in the right way. Don't have your managers, sending an email to HR saying, hey, I'm sending Lisa to you. She's concerned that, we had an outbreak at the facility. Things like that can be twisted, and if they get put up on a screen in front of a jury of 12 licensed drivers, it can be problematic. So make sure the emails that are the confirming type emails are being done by your COVID response coordinator, by HR, whoever is the person consistently giving that message. All right, leave claims. I'm gonna go really quickly through leaves because there's a whole lot of information on leaves. But the Family First Coronavirus Response Act, the FFCRA, expired December 31st, 2020. You can right now still provide up to 80 hours of pay for employees that either have COVID or have been told they have to stay at home, or they're responsible for caring for someone that has COVID. And you can still take a payroll tax credit at least through the end of this month. That might be extended, but you do not have an obligation right now to provide people with 80 hours of paid time off as you did last year. However, many cities in California have their own sick leave ordinances. Thankfully, none of them are in Orange County because we like businesses in Orange County. And it probably won't surprise many of you that around the Bay Area, virtually every city has a sick leave that is unique to that city, and Los Angeles does as well. So if you have operations in any of those cities, make sure that you're checking that you're providing the appropriate minimum wage, the appropriate sick leave, whatever that city requires. Make sure that the employees that are working in that city, whether they're working from home or your facility, you're complying with the law. Types of things are getting employers sued. The number one thing is not accommodating employees when they raise an issue related to some kind of a leave, even if they don't have the right to a leave anymore. If an employee says, look, I'm scared to come to work, it's probably just easier, and certainly more conservative in terms of your liability, just to give them some kind of an accommodation, whether it's working from home or whether it's an unpaid leave. I'm not suggesting that you start paying people to work from home because they don't want to come to work. You should not do that, because you're going to just encourage more people to do that. But for people that don't want to come to work, give them an unpaid leave and just say, look, when you feel safe to return to work, your job is waiting for you. Or maybe you give them we'll give you another month unpaid leave. Work with them, and again, document all that, so that you don't get a lawsuit claiming that you failed to accommodate people. OSHA, the Occupational Safety and Health Administration, and the Cal OSHA came out with new guidance on November 30th of last year. It's summarized on our blog, and the link is here. But for purposes of the 14-day isolation period, the 10 days after they test positive, all those things, that's all set forth in the new OSHA guidance. But in a brief summary is, if an employee is exposed, any reasonable, whether it's at work or somewhere else, and they know they've been exposed to COVID, they should isolate for 14 days. If you tell them that they need to isolate for 14 days, you need to pay them for it. Even if, and it could be sick time, it could be vacation time, PTO, whatever. If they're exhausted, all those things, the safer course of action is, if they were exposed at work and they were, pay them for the 14 days isolation period. If someone has tested positive because for whatever happened in their life, they picked up COVID, 10 days after they have tested positive, they can come back to work. You cannot require them to have a negative test to come back to work, unless you're requiring all of your employees to have a negative test every day to come back to work. And by the way, every time you require an employee to get tested, you have to pay for it. And if it happens in the workplace, and you're telling them, hey, go get tested, you have to pay them for the time during the workday to go do it. It's best to tell them you should go to this particular clinic, whether it's US HealthWorks or whatever clinic you use for your workers' comp. They're all doing the testing. Send them someplace specific so they don't go and get the super expensive rapid test that is available. And in the cost ranges from the $20 test, which it's a copay covered by their insurance, to the rapid test, which is not covered by most insurance, that can cost up to $300 a pop. So when you tell employees to go get tested, make sure you tell them where to go. And if it takes longer than a couple of hours, you may want to talk to them about where they went and why they decided to go to Santa Barbara to go get their test done. Overall, if you have a leave situation where someone's asking for a leave, like I said before, grant them the leave. Make it unpaid, but be the kinder, gentler employer that doesn't get sued as often. Wage and hour claims. Some of these we mentioned already, but very quickly, if you have employees, and these are all really unique to COVID, but if you have employees waiting in line to be screened, whether the questioning or the temperature screen, you got to pay them for that. If they get up there and they answer if they say, well, yeah, I've had a fever and cough for the last couple of days, and yeah, I really feel terrible. Even though it was stupid for them to come to work, you now have to pay them for showing up to work. Like I said, minimum 2 hours, maximum 4. If you're telling employees, look, and this particularly happens like a restaurant environment, look, we're not sure how busy we're going to be. We need you to be, standing by to work. As long as they're able to do things in the normal life, chances are it's not compensable time. But if you tell the employee, look, you have to call in at noon, and we're going to tell you whether or not you're going to have work that evening. If they call in at noon and are told that there's no work for them that day, they've essentially shown up, and you got to pay them at least 2 hours for doing that. So be very careful with any kind of on-call policy or standby policy. Have counsel take a look at it, because the policy in and of itself can give you liability, even when you think, look, this is what we've been doing for years. COVID has changed everything. There's a whole lot of lawyers willing to jump in and claim that your policy, which you've been using for the last 10 years, is now illegal. If you're working from home, folks, wage and hour claims range from, you didn't provide me with a laptop, And then one of the most important things, if you remember nothing else from today's conversation, if you have people working from home, you have to pay them a stipend, or you should pay them a stipend for whatever incidental expenses they have from working from home. They're going to have increased electrical costs. They're going to have increased internet charges, maybe. Maybe they're running their air conditioning more often, whatever the issue is. There's a lot of costs that are difficult to quantify, but everyone's going to agree, well, yeah, I guess if people are working from home, they're going to spend more money on electricity. In lieu of trying to figure out and have people, tell you what their pro rata difference in their electricity is, give them a stipend. Have it part of the work from home policy, and have the stipend be, $25, $30, and tell them, we're going to pay you $30 a month to cover your incidental expenses related to, work. Any, actual reimbursable expense, we expect you to provide documentation, submit an expense report for things like your electricity, your internet charges, toner for your printer, paper, incidental things like that. We're going to give you $30 a month to cover all of those. If at any time you feel that your actual expenses have gone beyond that, let us know, and we'll reimburse you pursuant to our expense policy that you normally would go through. But otherwise, the $30 is meant to cover that. I have not found any plaintiffs' lawyers yet that have said that they're planning to sue, or they think they can sue over the amount of the stipend. But folks that have, employers that have sent folks home to work from home that did not provide a stipend, they are all getting sued. It is the new, meal and rest break class action lawsuit in California. So employees working from home have to be given some kind of a stipend to cover incidental expenses, and they have to be told that that's what that money is for. And then when they come back to work, you turn that stipend off. If you have employees choosing to work from home and they're non-exempt employees, you still should pay them a stipend, because they're going to incur some expenses. If you have exempt employees that can work wherever they want, or you got people working a hybrid model, I don't know if I pay them a stipend, because you're not keeping track really. You don't know that they're working from home all the time, and particularly exempt employees. I mean, they're probably working from home all the time anyway, on the weekends and at night. So, I'm not saying you have to do a stipend for everyone, but non-exempt employees that have been assigned to work from home, you absolutely need to do that. Make sure that your pay stubs are properly tracking PTO and sick leave. If employees are using it because they have COVID, or they have someone at home that they're taking care of, make sure that you're tracking the sick leave or the PTO properly, so you don't get a violation for a pay stub violation. Employee privacy. One of the ways that companies have been trying to avoid a lot of this liability is they say, well, we got these great monitoring programs. So we're sending people to work from home, but it's great. We got a camera on their computer and we can see when they're working. So we know when they're working and when they're not. That's probably a really horrible idea. Zoom calls are fine. People are prepared for Zoom calls, but there is software out there that turns the camera on at random times and actually takes pictures of your employees without their knowledge. The problem with pictures is not only do people have morning face or morning hair, but you can learn a lot from a picture that you otherwise don't want to know. You can learn if your employee is pregnant. You can learn, if your employee appears, yellow and their eyes appear yellow, they're jaundiced, they've got some kind of a liver issue. There's, lots of reasons why you don't necessarily want to be monitoring your employees, either by video or taking still shots without their knowledge. You're also violating their privacy. In California, Article 1, Section 1 of the California Constitution says that everyone has an inalienable right of privacy. It's unique to California, not surprisingly. Again, we have really good weather, but taking pictures and video of employees without their consent gets you in trouble. So if you want to do that, you need to tell employees, look, this program is going to take screenshots of what you're working on. It's going to take a picture of you. You're going to have morale problems. Employees are not going to like that. And the most important thing, however, is you cannot, and there's software out there that allows you to monitor employees without their knowledge, audio and video. Audio in California, it's not just illegal, it's a crime. So every single time you tape, I'm old. Every time you take an audio recording of an employee without their knowledge or consent, that's a separate violation of $2,500. If there's someone else in the room with them, that person has also just had a crime committed on them by you because you bought a software, and the software you bought is absolutely going to have a disclaimer on there saying, we're not making any representation as to whether this is legal. We're just telling you what it can do. So before you do any kind of monitoring of your employees, keyloggers, doing video, any of that, have it run by competent labor counsel. Make sure that you're not doing something that's going to get you sued. And make sure that if you are monitoring employees, excuse me, that you're not divulging any of the information you learn or any medical information. And a lot of employers have been thinking that they're terribly brilliant to go on social media and document the fact that their employees are working from home or at the beach, or they're at a motocross event, or they're watching their kid's soccer game. All that's great, but are you doing that same level of snooping on all of your employees, or just the ones that are younger, older, male, Hispanic, whatever the issue is? Are you treating people all the same? Before you do any kind of monitoring, make sure you run it by counsel, and make sure your counsel has a really good malpractice policy so that he or she can give you advice and cover you if the advice goes south. All right, reporting requirements. This is part of the November 30th OSHA guidance, but very quickly, if you have a positive case in the workplace, you have to report it within 3 days to your workers' comp carrier. You have to provide all this information to them about where it happened, when it happened, who else was there, so they can start doing, so that they have the information for the purpose of the workers' comp claim that may be coming. If you have a case since January 1 of 2021, so since 2 months ago, you need to let all the other employees in the same facility know you had a positive case. You cannot tell them the employee's name or identify the employee. You can't say we had, someone in, Sector 6 that had COVID, because everyone knows, the only person in Sector 6 is Jane Doe, and now everyone knows that she got sick. You can't divulge that. You have to let all the employees know, hey, someone in your immediate area or your facility has been infected. If you need a template regarding that letter, send me an email. I've got that template, and to notify all your employees. And it doesn't disclose the name of the individual, but it will perform the necessary reporting so that employees can go get tested. And by the way, if you tell them to go get tested, you got to pay for it, and you got to pay for the time spent doing it. If you have 3 or more cases within 14 days, you have an outbreak under California law, and you have to report that to your local county health department. Orange County Department of Health, so they're happy with the logo over there. Just Google them. They've got a reporting requirement. It's very, very easy. They're going to ask you a bunch of questions. One of the first questions they're going to ask you is, do you have a COVID-19 response plan? And if you say no, they're going to be a lot more interested in you. They're going to want to do some contact tracing. They might call the employees. They might talk to them. You can provide governmental agencies the identity of the people who got COVID. And again, it's 3 cases within 14 days. So the first case, 14 days forward. If you have 3 cases within a 14-day period, you got to contact the county. You have to do that within 48 hours, or you face sanction, mostly by OSHA, because OSHA is going to come and say you didn't follow the law and you had another case, therefore you're not a safe and healthful workplace, so we're going to shut you down. You want to avoid that. I haven't seen a whole lot of businesses being shut down, but the ones that I have seen shut down are ones that, when someone calls them, they say, yeah, I don't know what a COVID-19 response plan is. Yeah, we haven't done any training on that. We've just been watching the news. All right, we're almost on the last slide. Just very briefly on vaccinations. Vaccinations are widely available, and if everything goes swimmingly, by the middle of April, everyone should be able to get vaccination, hopefully at like Walgreens and Rite Aid. Right now, we're at phase 1B in Orange County, so healthcare workers, emergency services workers, things like that. But as the vaccine becomes more widely available, a lot of employers want to mandate it. The EEOC, the Equal Employment Opportunity Commission, has said, oh yeah, it's perfectly fine to mandate that your employees get vaccines. However, we're in California, remember about the weather. And in California, you cannot impose a vaccine on someone unless there's a specific statute. So think flu vaccine and healthcare workers, or public school employees and tuberculosis. Unless there's a specific law that says you can mandate it, and there's not one right now. You have to accommodate employees on their disability, medical condition issues, or a sincerely held religious belief. You can't ask the employee, like, what kind of disability do you have that prevents you from getting a vaccine? What you can say is, I need medical certification from a healthcare practitioner stating that because of your medical condition or disability, you can't get the vaccine. Or you need a letter from them, or maybe their priest or rabbi, whatever, that says, they can't get the vaccine because of their sincerely held religious belief. You can ask for documentation. And then after the person, if you do have a an encouraging vaccination policy, which is what I recommend. You encourage people to do it, but not mandate it. Get them to do it voluntarily. Make sure that the encouragement is not something like you'll get better shifts if you get vaccinated, or you'll make more money if you get vaccinated, because then what you're really doing is you're retaliating against people that didn't get vaccinated. If you want to offer people a day of vacation pay to get vaccinated, I think it's a great idea. Offer them an extra $100, that's a great idea. And when people get vaccinated, whether they do or not, all people still get treated the same way. People still have to wear PPE, they still have to socially distance, they still have to wash their hands, all those things, whether or not they've had the vaccine. All right, and this is the final slide. Again, if you have any questions at all of anything I've said, let me know. Shoot me an email if you want any templates on notifying employees, COVID-19 response plan, work from home policies, and like that. But make sure that you are monitoring all of the potential sites. Communicate with your employees frequently and in writing. Keep documentation on everything you're doing, so that when you have a COVID positive case in the workplace, you can document that you've done all the right things. And make sure, again, with the work from home, have a work from home policy and a stipend for everyone who's working from home. That's probably the most important thing for purposes of California employers to do to avoid liability. And with that, we're a little over, but Steve, we have any questions? I'm happy to do it now or later.
Well, we're going to do the questions now. That was certainly a very comprehensive overview of all the potential liability that employers face out there. It's amazing that businesses can even operate. Is there any, because I'm sure some people are thinking, well, I only have 1 or 2 employee business, so a lot of this OSHA stuff or CDC stuff or state stuff doesn't really apply to me. Is that accurate, or does this apply? I mean, if you have 1 employee, all this stuff comes into play.
Yeah, if you have 1 employee, all the OSHA, workers' comp, all those things apply to you. If you have 5 or more employees, the California Family Rights Act now applies to you. So employees get up to 12 weeks of leave. If you have 5 or more employees, that used to be 50, but as of this year, it's now 5. If you have 15 or more employees, you've got all the federal wage and hour issues that apply to you. And if you have more than 5 employees, the Fair Employment and Housing Act of California applies to you. So if you're really small, you can avoid some of the discrimination retaliation claims, but all the labor code claims, all the OSHA claims, it doesn't matter if you have 1 employee or 1,000. The only issue is how much you might be fined for if you're found to be in violation.
Okay, well, we do have several questions here. Let me see if we can try and get to some of them. So the first one is, it says, is the monthly stipend for incidental expenses required if staff is required to work from home? So
yes, well, it's not required, but if you want to avoid being sued in a class action or a PAGA type lawsuit, the best practice is to have a stipend. $25, $30 a month is what I recommend, and tell people it's for incidental expenses associated with working from home. If at any time they feel like they're spending more than that amount in a month, provide documentation and we'll reimburse you. And we reserve the right to increase or decrease that amount at any time. It's in the work from home template that I can provide, but it's one of the most important things that employers can do for working from home employees, because it's one of these things that no one thought about except a whole bunch of plaintiffs lawyers, and everyone is being sued for this right now. I probably have in the firm probably 40 lawsuits right now related to work from home stipends.
Okay, and I guess there's another stipend question here. Is the stipend required, which you're saying it's not required, so it's suggested, but would you suggest it for exempt employees as well?
I think it's probably best to do it for exempt. If the exempt employee is being required to work from home, give them a stipend, because they're also going to have incidental expenses. But if the exempt employee is told, look, you can work wherever you want, I wouldn't do a stipend, because they can work out of the office. The only time you want to make sure you have a stipend is when the employee can't work in the office and have to work from home. And the big issue now is with the hybrid workplace, where people are working part-time at home, part-time at work. Maybe you reduce the stipend on a pro rata basis, because you're now working at home 50% of the time. So instead of being $30, it's 15. Okay.
Question here. So obviously all of what you're talking about is in the context of the employer-employee relationship. So this question is asking, how is an all-volunteer nonprofit affected by these laws? So they're not employees, they're just volunteers. So are you still, does the nonprofit have to be concerned about the things we talked about today?
If the nonprofit is religiously based, so it's a church or a temple, synagogue, what have you, they may very well be exempt from the Fair Employment and Housing Act. But otherwise, if you're an employer in California with 5 or more employees, you're subject to Fair Employment and Housing Act, regardless of whether you're a 501c3, C4, C5, what have you. If it's a for-profit or not-for-profit, you're treated the same way. The labor code violations also exist, and that specifically applies to the issue of volunteer. You may have folks that are working for you that say they're volunteering, but under the law, they may not actually be volunteers. So one of the first things that I would recommend that you do is if you have volunteers, have competent labor counsel take a look at them and make sure they're not being misclassified. Any more than you have exempt versus non-exempt employees being misclassified, or people working, like I said, outside salespeople. In my experience, most of the time when people have volunteers, they're actually not volunteers, they're actually employees, and they should be paid. And employees, by the way, can almost never volunteer. If you have, let's say, an administrative assistant, and he decides that he's going to babysit for you, that's substantially distinct from his regular workday. He might be able to volunteer that time, but an employee can't ever volunteer their time for a special project without coming up with labor code liability. And most volunteers for most nonprofits, unless you can establish that the volunteers were brought in and are doing services that are substantially distinct from what employees are doing, you may very well have a person that's a volunteer that really should be paid. So make sure you run that by counsel or competent HR folks to ensure they are actually volunteers.
Well, along those lines, there's another category of people that might show up at your workplace, and those are independent contractors. So how would you deal with them? I mean, and there's there's the whole issue of, are they really an independent contractor? That's that whole AB5 issue that love to talk to you about that, but we're running short on time. But how much of this does apply to someone who's maybe not technically an employee of yours, maybe is a legitimate independent contractor, but
same issue. I mean, the big issue now with the ABC test and AB5 is the test that's the B part of ABC is, are they performing services that are substantially distinct from what your other employees are doing. So for example, in a law firm, if we call in a plumber, he or she is absolutely an independent contractor. But if we call in a temporary lawyer or temporary paralegal, there's no way that person's an independent contractor under the new California law. So same thing with volunteers. If you have anybody that's performing services on your facility, make sure that they actually are a volunteer or an independent contractor, and you don't have liability toward them. And the only other issue with respect to independent, anybody that comes to your facility can still sue you for not having PPE, not socially distancing, all those things. And you may actually want to have the volunteers and the independent contractors be employees so that it's a workers' comp event and they can't sue you for negligence for something COVID related. It may actually be beneficial to have them all be employees for you.
Yeah, well, there's a lot of protection for an employer who follows the rules with employees, but
exactly right.
Be open field day with others that show up at your business. I think we're pretty close to the end here. We got one last question, just as getting the templates. Do you want them to email you directly for those templates? Is that
sure? Or they can email you, and you can pass them on to me, or they can email me directly. Okay. My email is there. Shoot me an email. Let me know what template you need. I'm happy to send it back to you. There's going to be a little lawyerly caveat on there saying that this is a generic template and all that kind of stuff, but they're pretty easily customizable and very straightforward.
Great. Well, we really appreciate your talk today. It certainly raises probably more questions than you even answered. It's a very technical area of the law, I imagine, and it's easy for an employer to screw up. So when in doubt, pick up the phone and call your legal advisor, or at least do some research at some of those websites that I think you put up on the screen earlier in the presentation. As just a reminder too, if you'd like a copy of the PowerPoint presentation, the link to get that is in the chat box. So please go to the chat box and you can find it there. I'll just quickly say thank you to Todd for visiting with us today and sharing his knowledge about COVID and the law and the human relations part of it. I'll just mention quickly that we have 2 other great programs this week if people have some more time to spend with us. Tomorrow, we're going to have a seminar. Our speaker will be Frank Kim. He's the county CEO for this county of Orange. He's going to be talking about the state of the county and the current state of the vaccination program here in Orange County. And then on Thursday, we're going to be with our mayor, Brad Avery. He's going to give us a state of the city talk and tell us about his agenda for this year, 2021, and what he hopes to accomplish and how we as a city are doing. So we're going to get the county overview on Wednesday, and we're going to get the city overview on Thursday. And you can find all these programs at www.newportbeach.com, as well as all the other things that we have to offer. Thanks again for being with us, and we'll see you all soon. Take care.
Thanks, Steve.